Hi, my name is Keith Sashaw, and I'm the president of the Association of Consulting Engineering Companies of BC, and we want to talk about contract language and what to watch for in agreements. There are several onerous clauses. The first one to watch for is indemnification. Professional liability insurance covers errors, omissions, and negligent acts of the engineer or their subconsultants. Indemnification should be limited to these three items: errors, omissions, and negligent acts. ACEC BC has worked with Encon Insurance Managers Inc. to develop a standard indemnification clause that is balanced and provides protection to both the client and the consultant. The second issue is duty to defend, and we're seeing this emerging more and more. This requires a consultant to pay a client's legal bills in the event of an action, even if the consultant has not made an error or if the issue is not directly related to the consultant's work. This could result in an uninsurable risk, and it's like writing a blank check. There was one instance in the United States where an engineering firm had a duty to pay the defense expenses of its clients from the commencement of the claim, even though the firm was eventually found not negligent. The firm contractually agreed to indemnify the developer from any and all claims to the extent they arise out of all or in any way connected with any negligent act or omission by the consultant. At its own expense, the firm agreed to defend any suit, action, or demand brought against the developer on any claim or demand covered herein. A trial court found that the defense obligation to be separate and distinct from the matters embraced by the indemnity clause, which limited indemnity to negligent acts or omissions. The firm was found to be not negligent at trial. In spite of this, the Court of Appeal affirmed a trial court's order to the engineering firm to pay approximately $550,000 to the developer's defense costs, including the cost to prosecute the unsuccessful case against the firm. Issue number 3 is the limit of liability. There are two ways to limit liability: one, for a certain time period, or two, to some monetary limit, either to a specific dollar amount, to a fraction or multiple of the total engineering fees, or to the amount of insurance available at the time a claim is brought. The new ultimate liability period under BC legislation is 15 years. In the absence of a monetary liability limit, liability is unlimited and may exceed the amount of insurance coverage. There was one instance where a supplementary general condition applied to a standard agreement stated that the effective limit of liability was $20 million. The value of the assignments issued under the standing offer are expected to average between $60,000 and $80,000 in fees. We strongly recommend you discuss with your insurer whether your policy can cover these kinds of provisions. Issue 4 is warranty. To stipulate that consultants provide a guarantee or warranty for the work is unacceptable. Consultants cannot carry insurance that would cover warranty issues. They have professional liability insurance. Project problems are best dealt with through a claims process. There have been instances such as the City of Fernie requiring the successful proponent to guarantee the work will meet the needs of the city. Our recommendation was to remove the sentence and also express the view that the intent of the deliverables are to meet the requirements of the contract, such as if the items supplied by the consultant and/or the services rendered by it are in any way incorrect or not in compliance with the contract, all correction costs must be borne by the consultant. Issue number 5 pertains to intellectual property and ownership of documents. Some agreements include provisions that overly invest intellectual property rights and ownership of documents with the client, rather than a provision that the client only acquires rights that has been paid for. ACEC BC, EGBC, and AIBC have adopted intellectual property guidelines. When followed, these guidelines reasonably protect a consultant's intellectual property and ownership of documents. Issue number 6, disclosure of legal actions. Some agreements seek to have consultants disclose any past or ongoing legal action that the firm may be involved in. Such a provision conveys a presumption of culpability on the part of the proponent. It is an unjustified intrusion on business practices and may conflict with confidentiality provisions, and the information disclosed cannot be evaluated objectively by the proponent. Issue number 7, standard of care. Standard is defined as what would be met by another qualified engineer acting reasonably under similar circumstances. Agreements should not require a professional engineer to meet a higher standard of care than that required under the Engineers and Geoscientists Act. Some RFPs contain wording such as leading edge, world class, or state of the art. Issue number 8, consequential damages. This is when project problems lead to a loss in revenue or some other indirect damage. An example is where a retail store opens late and the engineer is required to cover the loss of sales. Where this is a possibility, liability from consequential or indirect damages should be negated in agreement language. There are some other common problem clauses to watch for in reviewing professional services agreement. These include claims against individuals, prime contractor for site safety, disclaimers and limitations, dispute resolution, payment terms, termination, material change in insurance, insurance claims, and scope definition. These are all addressed on the ACEC BC's website under the resources contract language. We suggest you use standard clauses wherever possible, looking for alternative wording provided by ACEC 31. We're ACEC BC and we're here to help. Feel free to contact us at any time if you have any questions or concern about a professional services agreement that you're reviewing.